Hi, welcome back to Space Thoughts. Another significant event happened this past week in the announcement by NASA of what are called the Artemis Accords. Artemis referring, of course, to NASA's renewed effort to go back to the moon, right now set for 2024, at least that's the goal right now. There hasn't, a lot of details weren't given, and the actual accords themselves weren't actually presented to the public, but the underlying idea of the Artemis Accords is the Artemis program is inviting international cooperation from other states, and the accords basically are part of that cooperation. In other words, those states that want to participate in the Artemis program and going back to the moon, basically by doing so will, in a sense, be agreeing to these accords. And what the accords are doing, from what I can gather, is basically they're laying a legal foundation for norms or standards, acceptable standards of behavior for activities on the moon, which I firmly believe a lot has to do with space resource activity and commercialization. Now, back on April 6th, we had the executive order, which basically reaffirmed the idea of space resources and that the U.S. was going out to gather bring international agreement on the idea of space resources and create some sort of agreement on the idea of how these activities would be performed. I think, in my opinion, from what I've heard, is that the Artemis Accords basically tie into that. So in other words, these two efforts, the executive order and the Artemis Accords themselves, are actually part of each other instead of just separate efforts. So again, the idea is the Artemis Accords, in my opinion, are about what we call bottom-up rulemaking as opposed to top-down rulemaking through treaties, international bodies, and such. Bottom-up rulemaking be the activities of states creating customary international law or creating law through national legislation that filters up into the international community. Now, like I said, we don't know what the Artemis Accords say. I'm not going to sit here and speculate on what they say or what they're going to mean in the long term. But I think we might have some hint of what they actually are going to say or what some of the provisions with them might be from a group of guidelines that the NASA Advisory Council published last November, and they actually promoted it and published these. Let's go to these. Back in November, the NASA Advisory Council presented extraterrestrial resource principles, and basically these are 8 principles dealing with space resource activities. In other words, what it thinks are, fundamental guidelines or legal principles that should be followed in terms of space resource activity. Now, understand, NASA, this is an official U.S. policy here, but this is basically what the National Advisory Council is saying. These are principles that should be followed when we start doing space resource activity. So it stands to reason a lot of these principles that I'm going to go through very quickly here in the next minute or so will show up in one form or the other in the Artemis Accords when they're finally published. And of course, I'm really anxious to see what the Accords look like. But right now they are still in negotiation process, so they're probably not going to be released until at least there's a tentative draft out there that everybody is pretty sure that's going to agree to. Now, with that said, I'm going to go through some of these. I'm going to go through these 8 principles really, fairly quickly, just to give you an idea of what might pop up in these Artemis Accords when they come up. Principle 1, abiotic space resources shall be extracted in a manner that fully complies with the Treaty on the Principles Governing the Activities of States in the Exploration and Use of Outer Space, including the Moon and other celestial bodies. In other words, basically, the idea is space resource activity, the gathering, the harvesting, and converting of space resources is going to be consistent with the Outer Space Treaty. In other words, it is consistent with the Outer Space Treaty in this respect. The U.S. wouldn't be abrogating the Outer Space Treaty or withdrawing from it in any form, but basically interpreting it in the manner that space resources are basically allowed under the Outer Space Treaty. So this is a very important principle, and I think you're going to see this in one form or another in maybe the Artemis Accords. Principle 2, the extraction of space resources should be conducted in a manner that takes into account the United States' commitment to the United Nations guidelines for the long-term sustainability of outer space. Basically, these guidelines were adopted at COPUS last year. Basically, these are non-binding guidelines, very broad, very general right now, but they're going to be negotiated over the next couple of years to kind of, winnow down what they really mean. I have a lot of comments about the guidelines. I made a few of them for those of you who are subscribed to my briefing letter. I've discussed them and voiced some of my comments and concerns. Not going to do that here, just for the sake of time, and I don't want to get too far off topic. Just know that the U.S. signed on to these, and this principle basically says that any space resource activity should be consistent with the sustainable use of outer space. Principle 3, the extraction and utilization of space resources does not constitute national appropriation under Article 2 of the Outer Space Treaty. Very important, because Article 2 basically says no national appropriation. In so many words, says no national appropriation. And this is basically reiterating the U.S. position when it promulgated the Space Resource Law back in 2015, and it basically promulgates the position of Luxembourg and the United Arab Emirates, both of whom have domestic space laws that include space resource provisions. So in other words, this is totally allowable. We've interpreted the Outer Space Treaty to mean this is totally allowable under this. And I think in the Accords, you're going to probably see this mentioned in some sense. Now, I will, as an aside, as I mentioned, I was an observer to the building blocks for space resources, and during the comment period for the final draft, one of my criticisms was the building blocks never mentioned this, that the extraction of space resources do not constitute national appropriation. It was never mentioned anywhere in the preamble or anywhere through the building blocks, and that I found was, a critical omission in sense. And I argued it on several occasions, but it never showed up. So it's good to see this as the principle here. Whether or not this shows up as part of the Accords, we don't know. But I think this is very important to look at, reaffirming that the extraction and use of space resources is not appropriation under Article 2 of the Outer Space Treaty. Principle 4, per Article 6 of the Outer Space Treaty, states shall authorize and supervise the extraction of space resources from celestial bodies. Now, this phrase, authorize and supervise, points directly to non-governmental entities, i.e. private companies or private individuals that are performing space resource activity. It doesn't refer directly to national bodies. Now, the idea behind space resources, the way I've understood it and continue to understand it, is that the idea of extracting space resources isn't non-appropriation for private individuals, but still appropriation for for nations. There's some vagueness there, and that'll be kind of illustrated in one of these other principles. But this principle right here basically points that this is about commercial activity. And like I said, as I mentioned earlier, I believe Artemis is basically laying the path for commercial activity versus flags and, an Apollo flags and footprints type of thing, or just strictly a scientific endeavor. Principle 5, states domestic laws should facilitate government and non-government extraction and utilization of space resources, as well as the ownership of those resources. Now, I just spoke previously about governments performing space resource activity. I think it's appropriation, but this gets back into the term use in the Outer Space Treaty. And use tends to be, in my opinion, kind of like Janus, the two-faced god, in that it depends on who's doing the using. In other words, it depends on who's doing the using that really constitute what use is. In my opinion, that if a government is quote, using resources such as regolith and water ice to support a base, in other words, not doing it for pure profit, that isn't national appropriation. It's basically living off the land. So use in that context, and here, it is perfectly valid. Now, use from a private individual, on the other hand, you have use that is articulated by space resources, which basically says a private entity can extract space resources, convert them, possess them, and sell them. That is the other side of use that space resources created. So use, the way I interpret it, in my opinion, is that use is kind of two-faced and depend on who is doing use. And on one, so in other words, for example, if the government was to go up there and start, harvesting space resources to possess them, to convert them for profit, or for hard currency, or to otherwise convert them, I think that would be appropriation, national appropriation, invalid. However, if it used just to support a base, like I mentioned earlier, perfectly legal. On the other hand, private individuals can go up and their idea of use is to go up there and harvest them and convert them into for their economic benefit. So this is Principle 5 is kind of confusing in this respect, in my opinion. I don't know what the Accords will say about this, or whether or not any of these principles actually will be in there. But this would be probably something that I would hope we clarified, or at least come to an understanding in the Accords. Principle 6 refers to the principle of due regard consistent with Article 9 of the Outer Space Treaty should be taken into account by any state authorizing the extraction of space resources. Article 9 is a funny provision of the Outer Space Treaty in that it's one big long paragraph, but it has two legal duties and one legal right. The first legal duty is the duty for planetary protection, and that includes the protection of the Earth's biosphere from extraterrestrial contaminants, but also the contamination of extraterrestrial bodies. Now, the contamination of extraterrestrial bodies goes to the extent that the Article 9 wants to basically preserve those bodies for scientific research. Beyond that, Article 9 is the protection, the planetary protection in Article 9 doesn't really go beyond that, except to preserve it for scientific research. That first legal obligation, Article 9, has actually been enunciated and put into force by, say, NASA, for example, in its planetary protection protocols, and by other space agencies. So that legal duty in Article 9 has been executed. The second legal duty, which is mentioned here in Principle 6, the shall engage in consultations with the affected states. The consultation requirement hasn't really been invoked, and because it's kind of a touchy issue, and it really hasn't, and states are kind of wary about invoking it, lest other geopolitical adversaries will use it in the future to use it as a lawfare weapon in like the United Nations or in the international arena to basically harass a state who's trying to perform an outer space activity by causing, invoking a consult saying, well, you should have invoked a consultation, or you didn't invoke a consultation. And actually, the third part of Article 6 is the legal right to request a consultation. And that basically says if a state believes that an activity would cause harmful interference with another state's activities, it can request a consultation. Now that one hasn't been, that was invoked only once by Japan shortly after China performed its 2007 ASAT test, but I don't think it was really a timely request for a consultation, so it really had no legal effect. So in a sense, that legal right remains kind of in limbo as well as to whether it will, what its effect is, how it is used, and when it should be used. The second legal obligation and the one legal right, they're very touchy. A lot of it has to do with national security. Again, if you set a precedent for how these are used, basically other states might use it to their advantage to just harass and make a nuisance of themselves for other states performing space activities. So I'm really kind of on the fence about Article 9. I don't know whether something like this will come up in the Accords or whether some sort of middle ground can be reached, but it's something that I find interesting in these principles that NASA, the Advisory Council, has promoted. Principle 7, states shall share scientific information with the international community resulting from activities related to space resource extraction and utilization to the greatest extent feasible and practicable on a good faith basis and compliance with national laws, including but not limited to export controls, as well as protections for intellectual property and national and commercially sensitive data. In other words, if you're up there you're a private company performing space resource activity, in this case on the moon, you're acquiring a lot of experience about working in the lunar environment, about the regolith that you're digging in at the moment, about the nature, the chemical nature of the resources that you're extracting. That's all valuable scientific information. What this principle is saying is that information should be shared. However, it isn't saying you should share to the extent that it basically violates any export laws or other national security matters, any intellectual property or any other commercially sensitive data. In other words, we don't want to give away everything, but if the data can be distilled just down to the data that should be shared. And actually, this is kind of the spirit of the Outer Space Treaty. This is kind of this idea of sharing information about the outer space environment is part of the Outer Space Treaty. I believe in Article 1 of the Outer Space Treaty. And interestingly, that principle is also in the Antarctic Treaty. Principle 8, states shall inform the Secretary General of the United Nations as well as the public and the international scientific community to the greatest extent feasible and practical in compliance with national laws, including but not limited to export controls as well as protections for intellectual property, nationally and commercially sensitive data regarding the nature, conduct, and locations of authorized space resource extraction activities. States shall also provide timely notice to the Secretary General of terminated space resource extraction activities. This actually comes right out of the building blocks. This kind of paraphrases one of the building blocks. And I know one of the members who was a colleague of mine was a member of the building blocks, and so I'm sure this was he was very vocal in putting this into this. I don't know. This is an interesting one. And again, it's the idea of not keeping the international community in the dark of what's going on up there. Kind of falls in line with some of our treaty obligations under the Registration Convention in particular. But again, this is a recommendation of this is a principle adopted by the NASA Advisory Council. It's a recommendation. It isn't a policy position by the U.S. Whether it shows up in the Artemis Accords, we won't know. So those are the 8 principles, and like I said, they may be influential within the Accords themselves, or they may not even be part of the Accords. Who's to know? And again, like I said, I don't want to speculate on what the Accords say and judge them at this point, just because I haven't seen them yet, and I really don't like analyzing something that I really can't see. But these guidelines these principles issued by adopted by NASA, by the Advisory Council, I think are very significant, and a lot of them could find their way in one form or another into the Accords. So that makes them relative for the purpose of this video. But again, I want to stress that both the EO on April 6th and the Artemis Accords are extremely significant, because again, it shifts rulemaking, international rulemaking, from a top-down approach, international bodies, treaties, to a bottom-up approach where states promotes not only ideals and standards, but also best practices and such that actually become customary international law, and hence making them binding. Again, we won't know what's in the Accords until we actually get a look at them. Who knows when that's going to happen, but I, for one, am very interested in it. And again, this was a big news story, in my opinion, bigger than Tom Cruise actually making a movie for NASA about the ISS. Yes, I thought this was more interesting than a Tom Cruise movie. But again, interesting stuff, and very exciting stuff in the midst of what's going on in the world with this pandemic and such. So anyways, I want to wish you well. Stay safe, stay healthy, and we will talk to you next time.